because I had a few minutes, I thought I'll discuss the reporting about the sedition law. I am not sure if I am audible to everybody because I am using an and on mic. So if I am audible to everybody who is watching me right now, hopefully there will be a handful of you. Please drop in a comment with the with a description about the quality of the voice. Am I even audible or not? I have no idea. And of course, whenever you go live on YouTube, there is always a little bit of a lag. So the comments come in after maybe about 10-20 seconds. All right, great. So since I am audible, I am going to be talking about the reporting about the sedition law. Uh, I am one of the last few people to know anything about sedition law, have never fought any of these matters. However, there is one thing that I did want to talk about, which is our takeaway as lawyers, law students, and general citizens who are interested in understanding the legal landscape and how the law of the land works, which has always been an endeavor with this situation. So, when it was reported that the Supreme Court of India actually put a stay on sedition law, that was something which I found to be very, very uh, uh, unusual because of the fact that this is something that is not usually done. The last time something like this was done was perhaps the farm laws being stayed until the matter was resolved by discussion between the stakeholders, and even then I hadn't really delved very deeply into the matter. But when I read about this, I thought that there are other alternatives that could have been resorted to by the Honorable Supreme Court. And as it transpires, I don't have a copy of the entire judgment yet, the order which was passed by the Supreme Court, but I did get a hold which I'm hopeful is the correct version. That is the summary of whatever was decided by the Supreme Court three-judge bench led by the Chief Justice of India. So the last order sheet says this. I will read it out with you guys, and I'll also give you a comment about what the difference is between the news reporting and what actually transpired with the order. So the news reporting says that the Supreme Court of India has stayed 124A of the IPC. But from a preliminary reading of the actual order, which I shall post a screenshot, the screenshot that I have, I'll paste it in the description itself so you can access it, read it for yourself. But for now, what it says is this. In view of the clear stand taken by the Union of India, we deem it appropriate. Now, by the way, from what I understand, the Union of India, what they said was, earlier they were saying that sedition law works perfectly, there are no problems with it. But later, and again, this is just news reportings and reportings by a few colleagues of mine who were witness to these incidents, these court proceedings which were going on. And apparently, very recently, the Union of India said, the central government said that we are planning to review this law and see what can we do to change the situation, especially after observations by the Supreme Court that this is an archaic, very, very old law, colonial law, which needs to be done away with. That was the sentiment of the Supreme Court itself. So this is what the following actual order is. The interim stay granted in WP, that is writ petition criminal number 217, along with 216 of 2021, wide order dated 31/5/2021, shall continue to operate till further orders. Now, let us for a moment also look at this order which was passed by, again, another three-judge bench, but a different bench of the Honorable Supreme Court of India. Because again, if you don't know what is transpiring in entirety, it can be a problem. So let's for a moment have a look at this. The order of 31st of May 2021 says, again a three-judge bench, says ultimately that there shall be a stay on the respondents adopting any coercive measures in FIR number so and so against the two television channels which are petitioners before the court, namely TV5 and ABN. So there is no blanket ban on sedition law, at least from this first paragraph, by the Supreme Court bench today, right? This was apparently a quashing petition, and then I believe it was a quashing petition. Oh no, they were not quashing petitions, but actually writ petitions under Article 32 of the Constitution, directly filed before the Supreme Court, bypassing the state high court. And the FIRs which were registered. Now, please remember this, because this is something that I will be talking about. I'll be touching on in a minute or two. Sections 124, 153A, 505, read with Section 120B of the Indian Penal Code. Suo motu and FIR, suo motu on its own accord without any complaint by any aggrieved person. They say that this FIR was registered. They say that it is an infringement of my right under Article 19(1)A of the Constitution of India, and therefore, we challenge the registration of this FIR. That is what I believe order. The order stayed any coercive measures. Now, what do you mean by coercive measures? Basically means that you can investigate into the matter, but you cannot arrest. Coercive simply means you cannot place under custody any of the accused persons. So that, at least as an interim, urgent, immediate relief, is a huge benefit to the person who has been accused of this offense. Now we come back to the order of today, which hopefully, again, I don't have a copy in the entire copy. It could be a fabrication, but hopefully the way it is written, it seems to be the genuine copy of the order of today, because I just have the last page. Someone shared it with me. B. Now this is very, very interesting. This is on the basis of this, the reporting was done. And I believe that the media was not really wrong. I believe because of the interaction that orally took place between the court and the counsels with the media reporting, that often what the judges say in the court, now this is again another lesson for us, often what the judges say in the court about what they are going to pass, how they are going to pass, what will be the effectiveness or what will be the effective order, changes drastically when they are actually dictating the order. And in fact, I don't remember, but I laughed very hard just a couple of days ago when I saw a very similar instance. News reporting was Supreme Court says ABC, and then when the judgment actually came out, it was a completely different thing. Just a small twist of words, and something which was intended to be something else by the media turned out to be something completely different. And this again, another, as an extension of that, a lot of times we think, and this has happened on several occasions, the judges go into the interpretation of the law, applying that law to certain sets of facts, and they go into all sorts of ancillary issues, because of which when you read everything, you feel, and you read it quickly, it seems that there is something going on. And when you read it in detail, and if hopefully it is unambiguous, it turns out that it's a completely different thing altogether. So anyways, we now come to para B, and I know I'm stretching it out, but again, this is something that needs to be dealt with. At least, it's a learning for all of us. And another reason why I wanted to make this video was because I was discussing this with somebody else who again was talking about how the Supreme Court stayed the proceeding, despite the fact that I shared the last page of this order with that person, in a small group that I shared with that person, and the person said that this has been stayed, and I said again, if you read it, it has actually not been stayed. And so the situation is this, para B. We hope and expect that the state and central governments will restrain from registering any FIR, continuing any investigation, or taking any coercive measures by invoking Section 124A of IPC while the aforesaid provision of law is under consideration. So the Union of India says we are going to reconsider it. And the center and the states have been told, we hope. Now this hope is a very, very ambiguous term. And unless there is absolute accountability attached to any statutory provision of law or any judicial mandate, you cannot prosecute, you cannot impose any sort of liability, any sort of responsibility upon anybody. Because if you leave a little bit of leeway when it comes to making the statute or passing any judicial decision, or in your dealings with your fellow man, if you are not airtight, just like Sheldon Cooper, and very, very strict about every single clause with your dealings, every single instance that you go in court, and you're not absolutely, airtight with everything that you do, you can be taken for a ride. The interpretation is the name of the game. So the court says we hope. Now, if they say we hope and FIR is ultimately registered by some enterprising police official in any part of this country, now what do you think will actually happen? One thing is the court subsequently says, and let me perhaps just like quickly go with this, and then I'll explain what will happen if an FIR is actually registered. What's going to happen? Can they register? And if they do, what is going to happen? If any fresh case is registered under section 124A IPC, so the Supreme Court is already providing for we hope, and then if any fresh case. So they are envisioning they are envisioning a situation where the center and the state say we can still do it. So if any fresh case is registered, affected parties are at liberty to approach the concerned courts for appropriate relief. Now, what do you mean by appropriate relief? Two sorts of appropriate relief. As an urgent appropriate relief, there is anticipatory bail. The Supreme Court itself has said that we hope that while the center is reconsidering, let us not register any FIR. So if you are going to try and arrest me under the sedition law, which is punishable up to 3 years of imprisonment, because of course it is a non-bailable offense, at least please grant me anticipatory bail with all of this going on. And the second appropriate relief is quashing. Now, anticipatory bail, I am imagining a lot of people will get anticipatory bail. 99% of the time there won't be any difficulty. And this is the reason why I was so apprehensive when I read these news articles, because I said, what if there is an actual very, very legitimate, very concerning, very unanimously agreeable challenge to the sovereign nation? What does the nation do? Anyways, there is a solution to that as well that I will be discussing. So remind me if in case I forget. There are two things that I have to discuss. What if an FIR will actually be registered? What will be the implication for the person registering that FIR also? Of course, the court says you can go and seek anticipatory bail. What will be the consequence for the person registering the FIR? A, and B, now I already forget. Well, we'll get to that. So anyways, point number D, all pending trials, appeals and proceedings with respect to the charge framed under section 124A to be kept in abeyance. Adjudication with respect to other sections, if any, could proceed if the courts are of the opinion that no prejudice would be caused to the accused person. Now here as well, it is very, very interesting. Now, in a certain sense, 124A has been stayed, but it is very relevant to note that the court has said all pending trials, appeals and proceedings. Now, proceedings should ideally also include investigation. But looking at the prior few paragraphs, it now seems that the Supreme Court, what it intended to say was, with this slightly cryptic order, is that you can, if you choose to invite our wrath, you can choose to register an FIR, but if you do register that FIR, you can, the person can seek the appropriate relief. One is anticipatory bail, and the other aspect that I was trying to talk about was whether you can approach the High Court immediately for quashing of the FIR pending reconsideration by the court. And this can go either ways. The High Court can say that because the Supreme Court has passed this order, we say that nothing should survive and everything should be quashed right away. Or the High Court can say that again, because of the interpretation, it can choose to interpret it either ways. The High Court can say that I interpret it to say that the Supreme Court meant you can investigate, but no trial shall happen. And of course, the accused person will be given anticipatory bail with a lot of, with a very liberal view by the sessions courts and the high courts across the country. So point number E, in addition to the above, Union of India shall be at liberty to issue the directive as proposed and placed before us to the state government, union territories to prevent any misuse of section 124A. And finally, above directions may continue until further orders are passed. This ultimately is in a way a request to the central government and the state government. Please don't force us. Please don't force us to pass any strict orders in which we will be exercising a little bit of judicial overreach. And please exercise restraint yourself and do the right thing. Does the government actually do the right thing? The problem is as was also noticed despite the judgment, say for example, the judgment of Shreya Singhal versus Union of India. The court struck down the provisions of Section 66A of the Information Technology Act, saying that they are unconstitutional. Despite that, I believe almost for another several years, right up until maybe a few months ago, when the Supreme Court very heavily for the nth time came after the erring police officials and said, now if you do this, tumhari khair nahi. And so at that point of time, the police stopped registering FIRs under Section 66A of the Information Technology Act. And here also, I see a lot of potential for abuse. And now I wrap it up by saying, what will happen if an enterprising police official actually goes ahead and registers an FIR? One thing is, of course, anticipatory bail should be hopefully easy. High courts may or may not quash the FIR, depending upon how they interpret these 2 pages, and so much of hell is going to break loose. But what's going to happen to the erring officials? Of course, if the Supreme Court or the concerned High Court or the magistrate court having jurisdiction over the police station itself, if they were ever strict enough with the police that the police would actually be afraid of severe repercussions. Now, of course, this is a nuanced point. It is not that the police do not respect the judiciary, but they also understand what are the final implications. If I am found to be corrupt, then yes, I can be suspended, I can be arrested and face trial under Prevention of Corruption Act. But if I am, say, flouting, and that too when there is a little bit of leeway given here and there, if I am flouting the provisions of the law, of course, with a little bit of blessings from my senior up officials who also have their vested interests, a lot of misuse I can see can still be happening. Except, of course, if the Supreme Court in the very near future comes again and puts down the gavel and says, we are not going to allow it to happen. So, I was intending to actually have it to be just like a 2 or 3 minute video, but I've kept talking about it, and hopefully I made sense. Hopefully this was not incoherent babble, and some of you actually got a little bit of learning about whatever I was trying to convey over here. It is about how judges have to also exercise self-restraint in pending consideration by the union, not striking down or putting on hold the sedition law, encouraging the union to do the right thing. And what will ultimately the union and the states, what will ultimately be doing, that's a different thing altogether, and I've already cited my apprehensions. That is all. Hope these 18 minutes were worth your time.